Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Let's talk about the law of the 4th of July, specifically a thing that, lots of people enjoy, which is lighting off fireworks.
And those people are the enemy of my dog, who will be spending the holiday in my closet, shaking in terror.
Oh,
she hates fireworks.
Poor Mitty. Don't let her listen to this episode.
Welcome to Law and Chaos. It's the 4th of July, and we're going to celebrate in the way that seems least inappropriate at this moment in our nation's history. We're discussing the law of fireworks, also the latest with Kilmar Abrego Garcia and Trump's lawyers falling all over themselves in Iowa. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I mean, it's hot. I'm ready for it to be the weekend.
You have any big plans for the 4th of July?
No, but I'm sure I will do something fun. I have plans to not work tomorrow.
That is an exceptional plan, I think.
Yeah. And you, sir, what are you doing this weekend?
I'm not sure yet. There's a parade that I might go to. I'm usually not a big parade guy, but I think it's really important right now, if you love this country, and I do, to show that, not just one political party does at this moment in time. So,
right. Patriotism is not just the property of the Republican Party.
Exactly.
Okay. Speaking of patriots, who think that they are patriots, how do you like that segue? The January 6ers, not content with getting a full pardon, are now planning to sue the government for something. They want money. I mean, they're going to sue the government for money. I'm not entirely sure what the cause of action might be.
Yeah, I don't either. Tortious enforcing the law against insurrectionists, and then there's a change in administration. I don't know. This is obviously modeled after the family of Ashley Babbitt, who was shot by the Capitol Police while participating in the riot, and sued the government for $30 million. And
her husband did, yeah.
Yeah, well, right, her family, yeah. And the government decided to settle with her for $5 million, and that triggered the radar of a whole bunch of grifters.
Yeah. So actually the cast of characters here is pretty familiar. One is Peter Tickton. He was Trump's roommate at boarding school these many years ago. He was responsible for getting him named ladies' man in the yearbook. I just threw up a little bit in my mouth. Tickton was the lawyer along with Alina Habba, who filed that RICO troll suit against Hillary Clinton and James Comey and Rod Rosenstein and Perkins Coie and 50 other people that got them sanctioned to the tune of $1 million by a federal judge in Florida. But that is not stopping Peter Tickton. He's filed a bunch of other ridiculous lawsuits. He is joined by Mark McCloskey, who you probably don't remember.
Sounds familiar, yeah.
Yeah, no. If you're a reader of Above the Law, where you and I write, Andrew, if you're a reader of that site, you probably spend a lot of time reading about him because he's so goddamn funny. He is a lawyer in St. Louis who rose to prominence by pointing a gun at Black Lives Matter protesters in, I believe it was 2020. And
behind a huge gate in his community.
Yeah, he and his wife.
Turrets and a moat. And I mean, it was just, preposterous.
Yeah, it was ridiculous. So he points a gun at them. He gets kind of prosecuted for this, pardoned by the Missouri governor. And he kind of rode it to prominence as a Republican. He turned out to be an absolute kook. But they tried
What
to
are the
disbar
odds?
him. Yeah, no, what are the odds? And speaking of kooks, joined on this adventure is attorney Sidney Powell, who is still licensed to practice law, which is kind of really great if you're Rudy Giuliani or John Eastman. Anyway, the three of them.
Ken Chesbrough, who just got disbarred. Yeah,
that's right. Wow, Chesbrough knew better, but Chesbrough wasn't always a crank. I believe that these three were always cranks. Anyway,
Sidney Powell was like Lady Lawyer of the Year in Dallas 50 years ago, back when it was called Lady Lawyer of the Year, right? Yeah.
Yeah. Okay. So the three of them supposedly represent 400 January 6 defendants who think that they're going to cash in and get some money from the government now. Presumably not by winning a case in court, but by extracting a settlement the way that Ashley Babbitt's family did.
Yeah, and if you're multiplying out 5 million times 400, I mean, Babbitt had a wrongful death claim, so these will probably not reach that amount. But what should stick in your craw is whatever large numerical figure you come up with the math. I feel pretty confident that the contingent fee arrangement with Tickton, McCloskey, and Powell is probably 40% of the settlement. So your favorite loons are about to become multimillionaires multiple times over, thanks to the Trump administration. Good job voting him back in office.
Yeah, McCloskey told the New York Times in March, the fact that a lawsuit or lawsuits will be brought is as certain as the sun rising in the east. The exact form of that sunrise has yet to be determined. Although I would point out, he said that sunrise in the form of those lawsuits was imminent in March. It is now July. No lawsuit has been settled, but I believe that I believe that they're stupid enough to do it. So here we go.
I don't think it's stupid, right? Right. They don't have to collude with craven is a word I would.
They don't even have to collude, right? The Talking Points memo, actually, we'll link to the article in the show notes. They're meeting up with Ed Martin, the pardon attorney, January 6th attorney, the one who was too vile for even this Congress to confirm to be U.S. Attorney for D.C.
Yeah.
Okay, well, let's move a little bit up the road to your home and mine, Andrew, Maryland, where the Justice Department is now suing every judge in the state over a standing order by Chief Judge George Russell IV.
Yeah, this standing order, we've talked about it on the show before. Essentially what it does is place a 48-hour stay once any petition for habeas corpus has been filed within the state of Maryland, preventing the government from shuttling that person into another ICE detention facility in some other jurisdiction and, trying to moot the process and make them start all over again. Needless to say, the Trump administration is hopping mad about this. They have sued the entire district court and named each and every district court judge individually. They filed suit in the District of Maryland. So, as you and I said, notwithstanding the fact that the administration has only a passing resemblance to the law, this is a case where you would, right? They filed a motion for all the judges to recuse themselves, and you would want that in this case, right? They are named defendants.
Yeah, let me jump in. Not to defend the Trump administration, but I understand why they're suing every one of the judges in the district, right? Those are the people who have the power to enforce this standing order, which they claim is illegal or ultra virus. I'm not sure whether I agree with that, or in fact, I agree with that, but I understand why they have to sue. Right. They have to sue all the parties, all of the relevant parties. I mean, I guess when I first thought about it, I thought this was an attempt to kind of get it out of Maryland. But as I think about it, I think it's both. Two things can be true. But as we said when we talked about it on the last show, the Fourth Circuit, the Chief Judge of the Fourth Circuit, has the authority to assign it to someone. And indeed, he has assigned it to Judge Thomas Cullen, 47-year-old Trump appointee. But this guy seems to be one of the more reasonable ones, despite the fact that he was confirmed in 2020. He got 76 votes. I think he's a basically normal person who probably understands what a standing order is.
Let's hope so. Obviously, that's not a great sign. I assume the assignment order does not specify how Cullen was chosen. I assume by random. I don't know, maybe they had a rock, paper, scissors tournament or something. But
Rochambeau.
Yeah, right. Obviously, I'm nervous about it, but I certainly agree with you that, this is not the equivalent of assigning it to Eileen Cannon.
Yeah, and speaking of random, it is July, which means that we have escaped from the hell panel at the D.C. Circuit. So all of these emergency appeals, because remember we had like 5 straight months where the panel was, like 3 Trump appointees or 2 Trump appointees.
Yeah, two of the conservatives on an 11-judge court that only has 4 conservatives on it. Like, we ran the math, really, really low probability.
Right. So this time there is 1 Trump appointee who is Gregory Katsas, but we also have judges Cornelia Pollard and Patricia Millay. One is an Obama appointee, one is a Biden appointee. They are very strong judges. They are good judges. So at least the emergency panel at the D.C. Circuit is not going to be completely insane.
Just in time for the Supreme Court to have blown up nationwide injunctions. Although, as we've said on the show, the way in which district courts are going to respond to that is by provisionally certifying class actions that are, nationwide classes or expansive classes to try and push back against the obviously illegal actions by the Trump administration.
Okay. All right. Let us again talk about Kilmar Abrego Garcia. Because today, Thursday, Judge Waverly Crenshaw Jr. of the Middle District of Tennessee granted Abrego Garcia's request to order the government to shut the hell up about him, or more specifically, to comply with their obligations under Local Criminal Rule 2.01.
Sort of. I mean, he granted it in a 1-sentence order that said, all counsel are expected to comply with the local rules of this court. It does not seem to me that this court is trying to pick extra fights with the Trump administration. Yeah. But, we've talked about the Trump administration making incendiary statements about pending cases in a whole bunch of different contexts now. And just as a reminder, in the Middle District of Tennessee, Local Criminal Rule 2.01 bars lawyers from making an extrajudicial statement other than a quotation from or reference to public records that the lawyer knows or reasonably should know will be disseminated by public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in this matter, including, especially, that will interfere with a fair trial. And look, the wording differs, but this is a bog standard rule in virtually every jurisdiction. Trump knows it because his own lawyers complain bitterly about imagined violations of it in both his civil and criminal cases, right? They cited it as evidence of supposedly malicious prosecution, and the bits that they dug up paled in comparison to what the administration is doing now,
Sure.
right? Yeah. So this ban is also something that is particularly well known to prosecutors. This is another norm that I don't want us to lose, right? Like in the Justice Department manual, there is a prohibition on providing the media with any information concerning a criminal defendant's prior criminal record, right? Because that's highly prejudicial, and that's the sort of information that once it gets out is very, very difficult to cabin. None of which, of course, stopped Attorney General Pam Bondi and her minions from saying insane, false, vile shit about Abrego at every single juncture, both in court documents and to the media.
Right. So Abrego's motion says, in announcing the charges, Attorney General Bondi held a news conference at which she detailed irrelevant, false, and wildly prejudicial allegations that Mr. Abrego solicited nude photographs and videos of a minor and played a role in the murder of a rival gang member's mother. That same day, Secretary Noem called Mr. Abrego a known MS-13 gang member, human trafficker, and serial domestic abuser. He is not charged with any of that, by the way. It's clearly an effort to retcon the government's illegal deportation by saying, no, we did it on purpose. And even if we screwed up, he deserved it anyway, which is, I suppose, an understandable PR goal, but it's still wildly inappropriate behavior by the government, especially by prosecutors. And it's not the first time that this has happened. A.G. Bondi flapped her yap about Luigi Mangione, too, potentially damaging the government's ability to seek the death penalty in that case.
Well, good. I'm against the death penalty in any case. But look, it's obviously not good that we have such a disgrace to the legal profession heading the Justice Department. But the death penalty is barbaric. It doesn't work. I cannot believe we still have it. Anyway, in this case, Abrego argued that the DOJ and Department of Homeland Security were poisoning the jury pool with their public statements about him. And the judge said today, all parties have to abide by the local rules, which I interpret as the judge saying that the Justice Department should keep its inappropriate public statements to, a dull roar.
Yeah, I'm going to take the under on that one.
Yeah.
These guys are willing to say the most horrible shit, true or not. Like, I don't think a court order is going to stop them, but I guess I interpret Judge Crenshaw as not really wanting to wade into this, maybe because he wants to avoid a fight about whether DHS is acting as an agent of the Justice Department, because I guarantee you that if called to account for it, Kristi Noem and Caroline Leavitt, who works at the White House, would say, we can say what we want. We're not a party to this case. No trial judge in Tennessee can order us to be quiet.
Well, certainly that is what they would say. What the court has the power to do is to order the Justice Department not to directly or through intermediaries disseminate such statements to the press. That is commonplace, right? Like, because otherwise prosecutors could do an end run around the local rules all the time just by, off the record leaking to, their buddies at various news outlets, right? Like, the court's order can extend to you acting indirectly as well. And what that would mean is that the line attorneys for the Justice Department would be responsible when Kristi Noem says, throws up two middle fingers to the court. But I don't know.
I think I kind of see it in a slightly different way, which is that in this case particularly, the Justice Department has tried to kind of wall itself off from the Department of Homeland Security. And we're not going to get into it on this show, but we've talked about that whistleblower report where one of the things which Erez Ruveni accused Emile Beauvais, the number 3 guy at the DOJ who is nominated for that seat on the Third Circuit, one of the things that Ruveni accused Beauvais and DHS of doing was trying to ensure that the DOJ couldn't disseminate court orders to DHS, that they've tried to enact this sort of firewall, which would give everybody at DHS plausible deniability if they broke if they violated the court order, right? And we've seen it with respect to Abrego Garcia, where the DOJ said, well, Judge, you should hold this guy because if you hand him over to DHS is just going to deport him. As if the DOJ were kind of a separate organ from DHS, as if that firewall, which existed in prior administrations, was still functional, was still extant, as if they weren't kind of all Trump's minions, right? And here, why would Kristi Noem know anything about this guy's criminal record if she wasn't getting that information from the Justice Department? So for her to say, well, I can speak about the case when she has non-public information being funneled to her by the Justice Department is really having it both ways. I mean, not that I think that's going to matter. I would agree with you that the judge is trying to get this case dealt with and turn it into, keep the temperature down by not picking a fight where he says, Caroline Leavitt, who works at the White House, can't say lies about Abrego Garcia.
Yeah, I think that's exactly right.
Okay, we're going to take a quick ad break unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, not for you, not today, not ever. Okay, so the trafficking case against Abrego is taking place in Tennessee. Remember, that's the one the DOJ cooked up in April after they'd already deported him to CCOT?
Yeah.
To all appearances, the government seized on a traffic stop in Tennessee in 2022 to formulate a story about him driving twice a week from Maryland to Texas and back with a van full of migrants, sometimes with his toddlers sitting on the floorboards, they allege.
It is worth saying every single time how much of a ridiculous, transparently obvious lie this is. It is 1,500 miles from Baltimore to Houston. Houston's a long way away. So what the government is saying is that Abrego drove 6,000 miles a week while holding down a full-time job in Maryland and also raising his family. That's not mathematically possible. For comparison, long-haul truckers, for whom this is their full-time job, average 3,000 miles a week, right? I guess if you're the DOJ and you bribe known actual gang members with, an offer to get out of jail and secure residency in the United States, they just might happen to testify as to whatever story you want. It just, might not make a lot of sense.
Yeah. Meanwhile, the original habeas case in Maryland continues in front of Judge Paula Ixinis, and there, the government admitted that they intend to deport Abrego to El Salvador or possibly a third country as soon as they take him into custody, which is one of those things that we were saying before the break, right? That they argue that there's no coordination, the right hand and the left hand, right? But obviously that's not true. That sent Abrego's lawyers running back to Judge Crenshaw in Tennessee because the magistrate judge in Tennessee granted Abrego bail. She said the government failed to meet any of the statutory requirements for pretrial detention. But after the DOJ told Judge Ixinis that they were going to deport this guy to God knows where, his lawyer asked the court in Tennessee to actually keep him in jail, which Judge Crenshaw did. And that raised another issue in Judge Ixinis' court because the government argues that the original habeas case filed by Abrego's wife is now moot because the government brought him back to the U.S. And so that case should be dismissed. And Abrego says no, because one, they're still arguing about the government's failure to turn over discovery. So there's a live dispute. And two, the original order required the government to bring him back and put him where he would have been before they unlawfully deported him. And Abrego argues that involves bringing him back to Maryland so that Judge Ixinis can adjudicate his habeas claims when DHS grabs him back up, as they say that they're going to do. Because remember, habeas has to be filed where the plaintiff is detained. And Abrego knows that as soon as they take him, they're going to do what they did last time, which is move him to Louisiana and Texas or wherever. So they're saying, you got to bring him back to Maryland so that we can file here, not whatever Fifth Circuit hellhole you'd like to forum shop him into.
Right. So Abrego is asking Judge Ixinis to order the government to move him back to Maryland, where he will be able to file his amended habeas claim in her courtroom. Although I suppose that argument is not as pressing at the moment because he opted to stay in jail rather than walk out and get kidnapped by ICE, which tells you a lot about ICE at the moment. In the meantime, Abrego has filed an amended civil complaint before Judge Ixinis. It alleges that he was tortured and abused at CCOT. Actually, it alleges a lot of things that I think are going to be important in a bunch of these deportation cases. So Abrego alleges on March 15th, 2025, defendants deported 261 non-citizens, including 238 Venezuelan nationals and 23 Salvadoran nationals, to El Salvador without going through any legal processes whatsoever in front of an immigration judge. And I'm flagging that because Homeland Security has represented in open court that they are giving due process claims to these detainees. Now, they're saying that it's minor and quibbling over that, but they're saying they are, including the government saying that it has allowed each and every detainee the opportunity to raise claims under the Convention Against Torture. The government has also said that the Convention Against Torture is satisfied if the country they are deporting people to pinky swears that it doesn't torture people. And clearly they're both lies, right? And that's not the standard in the Convention Against Torture. Every dictator that tortures people says we don't torture people. Anyway, Abrego says that he was at CCOT subjected to severe beatings, severe sleep deprivation, inadequate nutrition, and psychological torture. And Liz, you and I have read this complaint. It is chilling. I'm going to read a little bit from the allegations. Upon arrival at CCOT, the detainees were greeted by a prison official who stated, "Welcome to CCOT. Whoever enters here doesn't leave." Plaintiff Abrego Garcia was then forced to strip, issued prison clothing, and subjected to physical abuse, including being kicked in the legs with boots and struck on his head and arms to make him change clothes faster. His head was shaved with a zero razor, and he was frog-marched to cell 15, being struck with wooden batons along the way. By the following day, Plaintiff Abrego Garcia had visible bruises and lumps all over his body. In cell 15, Plaintiff Abrego Garcia and 20 other Salvadorans were forced to kneel from approximately 9 p.m. to 6 a.m., with guards striking anyone who fell from exhaustion. During this time, Plaintiff Abrego Garcia was denied bathroom access and soiled himself. The detainees were confined to metal bunks with no mattresses in an overcrowded cell with no windows, bright lights that remained on 24 hours a day, and minimal access to sanitation. That is torture.
He said that after a week, the guards separated out the guys with actual gang tattoos and put them in a different cell with real gang members. Remember, the government says that basically any tattoo is a gang tattoo. That's one of the reasons that they've justified sending all of these guys by saying they're all in MS-13. Abrego says the guards at CCOT knew he wasn't MS-13, but he says they constantly threatened to put him in a cell with the real gang members who would harm him. And he says that the guards just let the gang members inflict violence on each other without intervening. Continuing from the complaint. During his first 2 weeks at CCOT, Plaintiff Abrego Garcia suffered a significant deterioration in his physical condition and lost approximately 31 pounds, dropping from approximately 215 pounds to 184 pounds. On April 9th, Plaintiff Abrego Garcia and 4 others were transferred to a different module in CCOT where they were photographed with mattresses and better food, photos that appeared to be staged to document improved conditions. On or about April 10th, Plaintiff Abrego Garcia was transferred alone to the Centro Industrial Prison Facility in Santa Ana, El Salvador. During his entire time in detention in El Salvador, Plaintiff Abrego Garcia was denied any communication with his family and access to counsel until Senator Van Hollen visited him on April 17th. So it sounds to me like the Salvadoran government realized that this guy was going to be a problem and started taking steps to limit the blowback.
Yeah.
In court, the original complaint was 5 counts. That was violating the order withholding removal to El Salvador, violating procedural due process and substantive due process, both under the Fifth Amendment, and violating the Administrative Procedure Act and the habeas corpus claim. The amended complaint adds claims for unlawful arrest under 8 C.F.R. 241.4 and 287.8. Those regulations say an immigrant must be notified of the revocation of his release. And the new complaint adds a claim for unlawful detention beyond the period in which Abrego was supposed to be removed.
Yeah. I want to talk about the new counts a little bit here. And I should say at the outset, I am not an immigration lawyer. I've talked to some. We've had some on the show. We will have some come back. I do not fault what Abrego's lawyers are doing here because they are litigating at breakneck speed. And you raise all the arguments you can as early as you can. That being said, I think it's our job to say that there appear to be perhaps some deficiencies with these 2 counts. And I want to say that because if the Trump administration moves to dismiss and prevails, right, they're going to crow about it and lie and say like, see, look, this shows that, and so much of what he has to say is meritorious. And the potential problems here are, if anything, procedural, right? Like they do not go to the merits of his argument. There is no question that the government did violate that provision of the Code of Federal Regulations and the statute on unlawful detention and the interpretive case law. The question is whether you as an individual detainee get to sue, right? Like whether the statute and the regs create a private right of action. And I don't think these do, right? So the Code of Federal Regulations, Part 287, says that any violation shall be reported to the Office of the Inspector General. I don't know if that's even still, like, if anyone has occupied that. I know Trump fired that person. I don't know if that has been staffed. And then there's, an internal review process. The statute, 8 U.S.C. 1231, by its own terms, can only be enforced by the state attorney general on behalf of state citizens. So, look, there might be problems with these allegations. I think the larger issue is that the government's failure to abide by its own regulations is going to be relevant in the context of Abrego's habeas petition, right, and perhaps his other requests for civil relief. But I'm not sure they're a freestanding cause of action.
Yeah, so that complaint remains pending. But I do think, as we said, it raises a lot of interesting issues for other cases. Mm-hmm. There's the case JGG versus Trump, which is still pending in federal court in D.C. before Judge James Boasberg. Mm-hmm. And that is, it hopes to be a class action on behalf of the deported men who are in CCOT. And suggests a lot of things about their status. The things that Abrego says about his treatment in that prison suggest that they will make claims about having been tortured, right? That they will make claims about having their due process violated, right? He says that they just stuffed them all on a bus. In fact, he says, this is really interesting because the government has made all of these claims in court that it's giving people process before it shoves them out the door. And he says, no, that didn't happen. And that he requested process multiple times because I think he was picked up on March 12th and deported on March 15th. And that he said over and over again, I have an order withholding removal. I'm entitled to be here. I'm not illegal in the sense that the government refers to it. And they kept saying, well, we'll take you to an immigration judge. And then they just shoved him on the bus into El Salvador. And so that suggests that there was no process. Whatever the process the government is representing in court isn't happening. Right. And it makes a mockery of all these claims that the government says about, well, we're not sending them any place that they would be tortured, because quite clearly they are. But I think the most interesting part is what Abrego says about constructive custody, because it's very clear that the government could get him back anytime it wanted. Constructive custody is kind of a legal term that means you might not actually be holding somebody, but if you're paying somebody to hold them, you're the real legal custodian. Right. And he says, demonstrating defendant's constructive custody of plaintiff Abrego Garcia throughout his detention in El Salvador, he was not returned through any formal extradition process, and upon information and belief, this transportation occurred without any immigration parole paperwork or other formal immigration status documentation of any kind. So what he's saying is, not only were you guys in control of me the whole time, I can prove it because you could get me back by snapping your fingers. You didn't have to go through extradition. You didn't have to present papers and ask for permission, right? You could get me back by just asking, or having Marco Rubio ask to have me returned, which means that you always had control of my circumstances. That's the argument that he's making. And I think it's the argument that all of the plaintiffs in the JGG case are going to make, right? If you had control over Abrego Garcia when you sent him there and could get him back just by asking, you have control over us too.
Yeah, I think that is right on every single level, including the importance in future cases, right? Like what we've said on this show is, right, if Kristi Noem can go pose for photographs at CCOT and come home, the government can get anybody that, it wants home. But that's a podcast argument, not a legal argument. And I think the specific point that they did not need to invoke any particular legal procedures, right? They didn't have to go through extradition. They didn't have to, sign a treaty. All they had to do was ask. And all the Supreme Court has said is that courts can tell you to ask to facilitate the return of somebody who's been sent to CCOT. I agree with you that I think that's really significant.
Okay. In a minute, we're going to come back with some more silly stuff, some less depressing stuff. Don't go away. We will be right back after this ad break. And we are back. On Tuesday, Paramount agreed to pay $15 million to Trump's as-yet imaginary presidential library to settle a troll suit against CBS for tortiously editing Kamala Harris's 60 Minutes interview. The company also agreed to fork over $1 million in legal fees.
I know we're getting to the laugh soon, but this one is unbelievably infuriating because this suit was total garbage. It was filed in Texas under the state's consumer protection law. That is, the complaint said that CBS somehow defrauded consumers in the state, who, by the way, Trump is in no position to sue on behalf of, and also made him spend more money on his presidential campaign.
Which he also can't sue on behalf of. That's one of the things that makes me crazy. The suit was filed by Trump in his personal capacity. If the campaign had to spend more money, the campaign could sue on its own behalf, right? Trump can't sue on behalf of it. Also, television broadcasts are not consumer goods, and there's no evidence that this communication was beamed directly into Texas. And they filed it in the Amarillo division of the Northern District of Texas in order to get in front of Judge Matthew Kaczmarek, which they did. I cannot tell you all the ways this thing was ludicrous.
And yet, Trump used the levers of the federal government to extort Paramount, which needs the approval of the Federal Communications Commission for its merger with Skydance Media. FCC Commissioner Brendan Carr, a Trump loyalist, I guess I don't have to say that, right? Like, if you're in the government, you're a Trump loyalist. But Carr is, particularly ridiculous, was mouthing off before the election about, what he would do if he was ever in charge, and now he is. Anyway, Carr threatened Paramount with investigations over 60 Minutes, in which, by the way, it did absolutely nothing wrong. There was an entire law of the show 60 Minutes, right? Like, lots of people have been unhappy with how they have been portrayed on that show for, understandable reasons. It is not objective journalism. It has a point of view. And there's just well-developed law that says, they can edit their interviews. Anyway, Trump threatened to withhold approval of the merger while this lawsuit was pending. So with billions of dollars on the line, Paramount paid the bribe to the king.
Yeah, so California is threatening to prosecute the company under the state's corruption laws. And Democrats are saying that they will do that too if they ever get back into power.
Yeah, But I would note that the statute of limitations for bribery is 5 years.
Indeed. Good thing the Supreme Court made it basically impossible to prove bribery, which appears to be the bet here. But the resolution in this case sort of explains something happening right now in Iowa, which is that Trump filed a similar consumer fraud suit against the Des Moines Register and pollster Ann Selzer for a polling whiff that said he was going to lose the state. And he's represented here by the same dingus lawyer, Edward Palcic, who sued in Texas. And as we just said, Palcic just got that $1 million windfall, which may account for his dogged refusal to walk away from a losing hand here. At any rate, he keeps stepping on his own wiener in Iowa. Andrew, you and I published a piece at Above the Law on Tuesday, and we talked about this recently in episodes 136 and 138. But here is the TLDR. Ann Selzer was one of the most respected pollsters in the business. On November 1, the Friday before the 2024 election, she published a poll in the Des Moines Register showing Kamala Harris leading in Iowa by 3 points. In the event, Trump won Iowa by 14 points once all the votes were counted.
Yeah, just a little bit. In the lawsuit, Trump's lawyers keep saying that he won by 13%, which those were the results on election night. It expanded afterwards. So it kind of tells you everything you need to know about the lawyering here.
Yeah, that's a 17-point miss, but it is not a tort. There is no tort of being really wrong about polling. And even if there were, what injury could Trump possibly have suffered? He claims in the complaint that the campaign was forced to spend resources in Iowa, but A, that's probably a lie. B, they could have just not spent it there, even if the poll was accurate. And C, he won anyway. Right. And once again, the case is filed in his personal capacity. He wasn't out a nickel.
Yeah.
Okay. Nor was his presidential library. Anyway, the case was filed in Polk County District Court because state court judges are generally more reluctant to grant early motions to dismiss. They tend to think like, everyone deserves their day in court. Also, state court judges in red states tend to be Republicans. So Palcic figured maybe they could get the local Matthew Kaczmarek. But Palcic isn't really a details guy. So he filed this dumb turkey and then took his sweet time about serving it on the defendants, which meant that for a brief moment, he'd only served the Register's parent company, Gannett. And that allowed Gannett, which is a Delaware company, to remove the case to federal court under a doctrine called snap removal. Basically, they said, well, there's only two parties here, and one is from Delaware and one is from Florida, so there's complete diversity, and we will take one ticket out of state court, please. To which the clerk said, here you go, step right up, Mr. Gannett. And Palcic has been trying to get back to state court since then, and failing in hilarious fashion.
I'm not sure why Palcic had to go all the way to Iowa to learn civil procedure. Like, he could have just stayed in New York and listened to our show. But okay, so first, he tried to argue that there's no snap removal in the Eighth Circuit. And then he amended the complaint that he'd filed to add a couple of Iowa politicians as plaintiffs. That was a blatant effort to destroy complete diversity. That is, there would be people from Iowa on both sides, so it would have to go back to state court. And both times, Judge Rebecca Ebinger in federal court said no, right? She bounced the state politicians and ordered Trump to amend his complaint by taking them out. And she said snap removal was fine. She did throw Trump a bone of sorts by certifying that issue for immediate interlocutory appeal. That is, she said, okay, snap removal is a pretty corner, it's an edge case everywhere, and it hasn't really clearly been decided by the Eighth Circuit. And normally you wouldn't be able to appeal the denial of a motion to remand. But you know what? Trump, I'm going to give you special permission to take an immediate interlocutory appeal, knock yourself out, right? Which, his lawyers did. But they also asked for permission to delay filing their amended complaint, and that was a fateful error.
Right, because in May, the Iowa legislature unanimously passed House File 472, which created a brand new strong anti-SLAPP law in the state. SLAPP is a strategic lawsuit against public participation, and the new law allows media defendants like Selzer, The Register, and Gannett to file an expedited motion to dismiss lawsuits exactly like the one Trump filed. And if you're a defendant, you can recoup your attorney's fees in the process. So that law went into effect on July 1. So if Paltic had just amended the complaint in timely fashion as he was ordered to do, he'd have been fine. He would have beat that deadline.
Yeah, it would have been more than fine, right? Like that amendment would have taken an hour. And Liz, as you point out, all he had to do, in fact, all he was permitted by the court to do was to omit the two Iowa state goobers and delete any allegations included solely to support their claim. So, quoting from Judge Ebinger's order, no other alterations to the amended complaint filed on January 31st, 2025 are permitted. Trump may not add new parties, allegations, or claims in the refiled amended complaint. Except that Trump can never just obey a court order. So he had Paltic file this motion to stay everything in perpetuity throughout the universe pending appeal, which he lost. But Judge Ebinger threw him another bone by extending the deadline for Trump to file that amended complaint to July 18th.
Yeah, and then a few days ago, Trump's lawyers looked at the calendar and realized that July 18th was going to put them after that law had gone into effect, and that if they filed their amended complaint after July 1, it would post-date the new anti-SLAPP law. So if he got himself bounced back to Polk County after filing that complaint, he'd be potentially on the hook for Gannett and Seltzer's legal fees. But our Eddie is a resourceful lad, and he came up with one weird trick to get around that. Did it work? No, it did not. Was it hilarious? Oh my God, yes, it was. And we will yuck it up in the subscriber bonus.
And that is available to anyone who is a subscriber over at patreon.com/lawandchaospod or on our Substack at lawandchaospod.com. For everybody else, you will get this brief ad break, and we will join you in the final segments on the law of fireworks. All right, we promised you. Here it is. Let's talk about the law of the 4th of July, specifically a thing that, lots of people enjoy, which is lighting off fireworks.
And those people are the enemy of my dog, who will be spending the holiday in my closet, shaking in terror.
Oh,
she hates fireworks.
Poor Mitty. Don't let her listen to this episode. Okay. With Mitty safely in schedule. Let's talk about blowing things up. Last year, Americans spent $2.8 billion on consumer fireworks and set off 323 million pounds of pyrotechnics. And a lot of people break state and federal law to do so.
The devil, you say.
As always, don't take legal advice from a podcast. Okay, so let's start with the federal fireworks law. That is the Federal Hazardous Substances Act of 1960, or FHSA. It is 15 U.S.C. Chapter 30. Now, Congress doesn't have general police powers, so in the abstract, right, they can't just regulate or ban you from setting off explosives in your own backyard, even if they think that's a dumb idea and you might hurt yourself. So this law, like a lot of legislation, targets interstate commerce.
That is Article 1, Section 8, Clause 3 of the Constitution, the Commerce Clause. It says that the federal government has the power to regulate commerce among the several states. So that means if goods are shipped from Pennsylvania to Maryland, the federal government can pass laws regulating or prohibiting that. But for most of our nation's history, interstate commerce has been defined really broadly, right? You don't have to show that fireworks were actually purchased in another state. In fact, if the fireworks were manufactured in Maryland from Maryland materials, assembled by Maryland workers, and sold to Maryland residents only, they would still be subject to the Interstate Commerce Clause so long as they were capable of being transported across state lines. The federal law would still apply. And the language in the Federal Hazardous Substances Act prohibits the delivery for introduction of banned hazardous substances into interstate commerce.
And in practice, that means all fireworks can be regulated by federal law.
For now. I mean, it's worth flagging that one of the elements of the conservative project is to scale back the definition of interstate commerce. We saw that in the Supreme Court's NFIB v. Sebelius decision in 2012. Like, that decision narrowly preserved the Affordable Care Act's mandatory coverage mandate, even though Trump set it at 0 in his first term. But it did so on the grounds that it was a tax, not that healthcare is interstate commerce. And that was a major change to potentially curtail the power of Congress. I would say at least as many people travel across state lines for health care, that is, people going to emergency rooms where they get hurt out of state, for example, than drive across state lines to buy fireworks.
Oh, for sure. So, okay, under a broad theory of interstate commerce, for now, the FHSA prohibits what it calls banned hazardous substances. They are defined in Section 1261 of the Act. Hazardous substances includes toxic stuff, radioactive materials, and that sort of thing. But for the purposes of fireworks, it is defined to include any substance or mixture of substances that is flammable or combustible or generates pressure through decomposition, heat, or other means if that may cause substantial personal injury during or as a proximate result of any customary or reasonably foreseeable handling or use. So, butane isn't hazardous, even though it's combustible, because it's really hard to substantially hurt yourself when you're using a creme brulee torch.
I mean, those things are scary as hell. I think they should regulate butane. No, I'm kidding. Okay. Of materials that are considered hazardous, the Act bans any article that is either explicitly a toy or is susceptible of access by a child, which includes fireworks. And then the law exempts a couple of things from that definition. One is chemistry sets.
Ooh, I had one of those as a kid.
That tracks. Me too, actually. But apparently, Mr. Wizard had powerful friends in the United States Senate, because there's a long paragraph about how you can still sell those chemistry sets to children who have obtained sufficient maturity and are likely to read the chemical warnings.
I did none of that, but I did grow a lot of crystals.
I did not. I don't think I ever played with it. I mean, it was a nice gift. Thank you, Grandma and Grandpa. Anyway, the law also excludes common fireworks defined as toy paper caps, cone fountains, cylinder fountains, whistles without report, and sparklers.
AKA the stuff that's no fun. Also, I had to look up the delightfully 1960s soundy whistles without report. That refers to those super disappointing fireworks that, make the whistle noise, but they don't light up or explode or do anything fun. Everything else, right, that is not that definition is left to the Consumer Product Safety Commission to determine by regulation if the firework is too dangerous to permit to be sold. And again, in a pre-Trump, pre-Roberts Court world, this is how laws used to work, right? Congress would pass a law in 1960 and say, I bet technology will change. So instead of us just specifying stuff that's going to be obsolete any minute now, like whistles without report, we're going to let an executive branch agency continue to monitor and provide a list of dangerous versus safe fireworks.
Right. And not to beat a dead horse, but that is why the defunct Chevron doctrine was so useful, right? If Congress tells an executive branch agency like the Consumer Product Safety Commission to come up with a list of dangerous fireworks, and it's at all ambiguous what fireworks means, then courts should defer to the commission's determination of what counts as a firework rather than come up with its own definition.
Yeah, but if you do that, then presidents who follow the law can enact major changes to public policy through their executive branch appointments, like, staffing the Department of Education with directors who want to forgive student loans, or the Department of Labor with people who think wage and hour laws should be indexed for inflation and that non-compete clauses are generally oppressive. But I digress. Fireworks.
Yeah, boom, boom. Okay, we'll come back with Big Boom after this brief ad break.
Okay, I finally want to blow stuff up. The commission's regulations are part of the Code of Federal Regulations. It is 16 C.F.R. section 1500.17, and it declares as banned hazardous substances firework devices intended to produce audible effects, including but not limited to cherry bombs, M80 salutes, silver salutes. And by the way, that's another one that I had to look up. They're just apparently like super loud fireworks, but anyway.
Okay.
And other large firecrackers, aerial bombs, and other fireworks designed to produce audible effects if the effect is produced by more than 50 milligrams, 0.772 grains of explosive. Okay. And it also applies to banned firecrackers that could be confused with candy, which it says are things like dragon eggs and cracker balls. And I don't know if that word has changed definition, but when I Google dragon egg, I get the like kind of crackly firecrackers.
You didn't Google cracker balls?
I did not.
I assume it's like pop rocks, like in the sky.
Sure. Okay. So that's the federal law that is justified by interstate commerce. You can't legally buy M80s or cracker balls anywhere in the country. But federal law doesn't prohibit some really huge fireworks, right? Mortars, bottle rockets, stuff that really lights up the night or makes a lot of noise. But that's just the baseline.
Right. So to pick up on a loose thread from earlier, unlike the federal government, state legislatures do have general police powers. So they can pass laws simply because they think it would be a good thing for their citizens. And that system comes into play under the Supremacy Clause, which is Article 4, Clause 2, and it says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So the Supremacy Clause actually means a couple of different things today. At its most basic, it means that if state law and federal law conflict, then federal law controls. But it also means that the federal government has the power to declare that there are uniform nationwide standards in any area where the federal government has the power to regulate.
Yeah, that's called occupying the field. And for most things that the Consumer Product Safety Commission regulates, federal law does expressly preempt any state laws to the contrary. So in practical terms, right, that means that if a product meets federal safety guidelines, states can't impose additional requirements on top of it, right? Like a thing you bring into this country is either safe or it isn't. And you can understand as a practical matter why you'd want Congress to be able to set uniform standards, right? Like when other countries sell their goods here, you want them to be subject to a single up or down decision, right? Like not, oh, we can sell our t-shirts in Maryland, but not in Delaware. But fireworks are an exception to the Commission's general mandate of preemption. That means states can and do pass laws that sit on top of that federal minimum standard. And here, by the way, is where you definitely do not take legal advice from a podcast.
Yeah, we're going to go state by state, but for completeness, it's worth pointing out that 3 states leave firework regulations to each county. That's Hawaii, Nevada, and Wyoming. And Wyoming has 23 counties, which is kind of amazing since it has fewer residents than the city of Baltimore.
True, but as far as I can tell, all of those counties in those 3 states still generally permit fireworks up to the federal law, meaning mortars and bottle rockets and aerial fireworks and any firecrackers smaller than the M80, as do 28 other states.
I mean, what, are you going to bother your neighbors in Wyoming?
We are going to get some hate mail from Wyoming.
I mean...
We love you,
people to be mad at
Wyoming
us. No,
listeners.
I'm not. It's not hate mail. I'm just saying, like, there's a lot of open space there.
Exactly. Okay, so only one state in the country completely bans fireworks. That is Massachusetts, under the Massachusetts Code, Chapter 148, that prohibits fireworks, firecrackers, or any substance having such properties that it may spontaneously or acting under the influence of any contiguous substance or of any chemical or physical agency ignite or inflame or generate inflammable or explosive vapors or gases to a dangerous extent. And yes, that includes sparklers. It includes those little party poppers, the little tiny things you give to 3-year-olds
every
to throw
party
at the
has
ground.
a pooper, but not a popper.
Okay, so that's Massachusetts. 2 other states have very restrictive firecracker laws. Those are Illinois and Vermont. And in those states, they permit what they call novelty fireworks. So you can light off those horrible little black snakes, right? Like you can have sparklers, you can have party poppers, but nothing else, right?
It's very funny that they're called poppers. I mean, for no reason. Go ahead.
Okay. So if you're counting along, that leaves 16 states and the District of Columbia where the permitted uses are defined by state law as more restrictive than the federal standard, but not as far as, Illinois' Pyrotechnic Use Act of 1942, right, that only permit the novelty firecrackers. In those states, which include our home state of Maryland, they generally permit ground-based fountains and fireworks, but they prohibit aerial fireworks like mortars and bottle rockets.
And if you are curious as to where your state falls, we will link to a chart in the World Population Review. That's a data-driven website that principally aggregates demographic information. It's a great resource. Mm-hmm. And that is going to do it for us this week. I hope that you are staying cool wherever you are. I understand that this holiday is a little fraught at this very moment. I would just encourage us all to remember this land really is your land, and we will one day take it back.
Hear, hear.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.